why the Texas case may be a game changer. Only going to do this for the locals board. Viva Fry is going to be doing a vlog on it, I think later today, that he'll be posting. But the Texas case has the potential to be a complete game changer, and I'll explain why in this summarized brief video. So first, what's unique about the for those who don't know, the Texas Attorney General in the state of Texas filed an action in the Supreme Court of the United States against several other states for violating the Electors Clause of the U.S. Constitution and other provisions in terms of how the presidential election was conducted in November. And the reason why this case has the potential, if the Supreme Court is going to get involved, the Texas case is far more likely to be the case to do so than any other case. The reason for that is because the Texas case presents an easy means for them to resolve the issue without getting into the kind of nest of issues that other cases attract. It also allows them to do sort of a one-stop shop case to resolve all of it. The Texas case can be basically summarized as this. What people forget about the United States Constitution upon occasion is that it's mostly a compact, a contract amongst states, amongst state sovereigns, that came together and said, okay, here's how we're going to govern each other in a national government. The national government doesn't derive or arise from individual citizens. It arrives and derives from the states' sovereigns themselves. That's what it is. We had originally the colonial governments, and then we had the Articles of Confederation, and then we had the United States of America. Not United America, not United Americans, just the United States of America. So the states got together and said, here's how we're going to determine how we govern each other in a national compact. And that is the Constitution of the United States, including its amendments. And part of that was, okay, how are we going to, you could really say the parties to the Constitution are the individual state sovereigns, the individual states. And so the state said, what we're going to agree to do is that in terms of electing the President of the United States, each legislature will determine, each legislature of each state will determine how the presidency is chosen, first by choosing electors, and then the electors can also act independently, at least legally, in terms of if they choose to vote however they choose to vote. And the states can choose to bind them or not bind them, can impose consequences if they don't vote according to what the state's directive was, but they have a certain degree of independence and freedom of action. But fundamentally, it's that the legislatures of each state will be the ones to pick. They didn't say the states pick. They didn't say the state governments pick. They didn't say the people of the states pick. They said the state legislators and the state legislatures are the ones who will select the electors to the presidency. And in addition, the agreement was, through the 12th Amendment, that if for any reason there's a contest or dispute or controversy over who the states chose, and not a majority of electors have been, in fact, chosen without contest, then the House of Representatives will choose the president, voting again by state delegation. So that's what the states agreed to. The suit by Texas in the U.S. Supreme Court against the other states is that a bunch of states decided not to follow that. So it'd be like if two people had a contract and one party breached it, and they agreed that if there was a dispute, they would go to a particular court to adjudicate that dispute. And in addition, they would agreed in advance that if there, in fact, a legitimate basis for the controversy, then the remedy would be a certain thing. That's what you would expect to happen, and happens every single day in courts across America. If anybody has standing to contest what happened, it's the states who abided by the rules against the states that didn't. They set the rules. Those were the rules all the states agreed to. We all agree the legislatures are going to pick the electors to the presidency, and the complaint of Texas is that a bunch of states didn't do that. They had election officials in the executive branch, sometimes at the county level, sometimes at the state level, choose how the president was going to be, or how the electors were going to be chosen for the presidency, rather than the legislatures. The legislatures could choose to do it by election, but they couldn't do so in a manner that violated the Constitution of their own state, as occurred in Pennsylvania, which is the allegation there, nor could they do so as they've done in Michigan and Georgia and Wisconsin and other states, where they allowed people to vote in a manner different than what the legislatures laid out, including allow people to vote after Election Day or have their vote count even if it arrived after Election Day, as was the case in Pennsylvania, as was the case, at least in Nevada. The reason why Nevada was not sued is that was at least passed by the state legislature. It was not in Pennsylvania. There were certain counties in Pennsylvania that allowed people to, quote unquote, cure their ballot if they cast it illegally the first time. That was not passed by the state legislature. That was just selectively implemented by various government parts of the executive branch in counties in Pennsylvania. In addition, in Pennsylvania, for example, they also allowed the ballots to be counted without a signature match. The legislature put in a signature match requirement. The Secretary of State said, no, you really don't have that. The Pennsylvania Supreme Court decided that that somehow wasn't in the statute when it was. In Georgia, you had a consent decree that effectively gutted meaningful signature matches. And again, that was not passed by the state legislature. The use of drop boxes was not passed by the state legislature. So in some cases, ballots went out en masse that were not, again, passed by the state legislature in terms of the means of the excuse for balloting. The same thing in Wisconsin, where they allowed people to call themselves indefinitely confined who were not under state law to vote. And in all of these states, the margin of victory is less than the margin of ballots allowed to be cast in violation of what the state legislatures constitutionally authorized. So the reason why the suit is easier for the Supreme Court to take, first is procedurally and second is substantively. Procedurally, it's easier to take because any contest, any suit between the states, there's only one court in the country that has jurisdiction. It is the United States Supreme Court. The United States Supreme Court, there's people who think that this is like a petition for cert or certiorari. It's not. The Supreme Court has original jurisdiction and is in fact the trial court, and in certain cases, and in the case of disputes between the states, it's the only court that has jurisdiction. So it's not only that it has what's called original jurisdiction, not appellate jurisdiction. It also has appellate jurisdiction, but it has original jurisdiction over a lawsuit between the states. But it also has exclusive jurisdiction between a lawsuit between the states. Only the U.S. Supreme Court can vindicate Texas' interest in this issue. Texas has no other place it can go. It can't go to other state courts. It can't go to federal courts. The only place it can go is the United States Supreme Court. So in fact, there's some people who think that the U.S. Supreme Court can just unilaterally deny it. That's really not the case. It's like a suit filed in any other lower trial court level. They have to dismiss it on some particular grounds. Now, so the only procedural hurdle is people are identifying different kinds of cases where states have tried to abuse this privilege of going exclusively to the United States Supreme Court for both original and appellate jurisdiction. The U.S. Supreme Court makes the final decision, unappealable decision, because it's the final decision body and the first decision body, based on when the states have tried to abuse that in other cases where they're really suing for their citizens or they're suing for something else. This goes to the core of what the Constitution was all about. It was about, hey, we're going to get together and we're going to agree, here's how we're going to govern ourselves in the future, and we all agree to abide by certain rules amongst each other in determining national power over us, all the states. There's nothing more core to the constitutional compact than the Electors Clause saying this is how our elections will happen. And the other constitutional amendments apply to that. Not only the 12th Amendment, but also the 14th Amendment about due process and equal protection. So that if the state legislature takes action, it has to do so with due process, it has to do so with equal protection of the laws, but it itself has to be the body determining the rules of the electors being chosen. It can't be by the courts, it can't be by the executive branch, it has to be by the legislative branch. That doesn't mean they can't allow the executive branch to enforce the laws, that's clearly the case, but what the executive branch cannot do is decide its own means of how the election is going to be conducted, which is frankly what happened in Wisconsin, what happened in Michigan, what happened in Pennsylvania, what happened in Georgia. By contrast, the reason why Nevada was not sued as a defendant, the state legislature actually passed the changes that took place in Nevada. There's still some questions about whether certain enforcement was strictly applied, but that's a more limited question than the bigger question, that the Electors Clause question that faces the other states. So the state of Texas has said, look, we agreed to a deal. These other states broke the deal, and now they want to impose a president upon us who's in violation of the deal, who that if they had abided by the deal, the same president we in Texas elected would be the president elected for the entire country. That a majority of electoral votes would have gone to Trump, but for these other states violating the Electors Clause provision. And so the remedy does not have to go back to state legislatures. The remedy is to go to the House to vote by state delegation, where there is a substantial Republican advantage. So for procedurally, it's much easier for the U.S. Supreme Court to take it because it's an original jurisdiction case. There's more limits on their ability to dismiss. I mean, they can still dismiss, but if they're going to dismiss this case, frankly, that means they're not going to get involved in the election period, because this case procedurally provides the easiest means for the Supreme Court to take direct action. Secondly is substantively. Substantively, they don't have to throw out a bunch of votes. They don't have to get into the weeds of how whether certain votes were illegally cast. All they have to do is whether or not these states violated the Electors Clause or not. And if they did, then Texas has a right to make sure the Electors Clause is enforced. And there's already a built-in remedy within the Constitution for that to occur. Just as they agreed how they would choose electors, they also agreed which court would resolve disputes and controversies about that choice. They also agreed on the remedy if there was a violation. And that remedy is that the House votes by state delegation for the president. That's it. That's the resolution. That doesn't have to happen until January 6th either. So there's more time. So the U.S. Supreme Court can, all the way up until January 6th, frankly, say that we are going to enjoin any electors being counted from states that violated the Electors Clause of the Constitution, because that violates the rights of Texas, which abided by the Electors Clause. And so why should they lose their rights, contractual rights, really? The whole reason they agreed to the deal was this is how presidential elections would be decided. When a state decides, nah, we're just not going to abide by that, doesn't the remedy have to be to set aside the electors from those jurisdictions and go to the House, which is what the constitutional remedy is? That's why substantively it's far easier for the U.S. Supreme Court to rule in favor in the Texas case in throwing the election to the House than it is getting into the weeds of these other issues and other election contests and other cases. All of those cases help the court of public opinion, and to some degree the court itself can rely upon aspects of it. But the ultimate resolution does not require they go there. All they have to decide is one question. Did these other states violate the Electors Clause or not? Because if they did, then doesn't there have to be a remedy? And isn't the remedy what the Constitution provides for, which is the Supreme Court isn't deciding the election? The people who voted for their congressional members in those states and in the states across the country are the ones who decide it, and that's what the Constitution calls for. And if people have a problem with it, well, they should have voted differently for the House, because that was part of the power they were giving people when they made that vote. They chose to vote for whom they chose to vote for with full constitutional awareness, whatever their own individual awareness was. They have objective awareness, which is sufficient for legal purposes. That part of the power they're giving these members of Congress is the power to choose the presidency if an election is contested. And in this context, all they really have to prove is a violation of the Electors Clause. This allows the Supreme Court to set aside the election results without getting into the weeds of accusing states of fraud, accusing any party of fraud, or any of that. They just say, look, you agreed to a deal, and then you broke the deal. As they said in Mad Max Beyond Thunderdome, break the deal, face the wheel. Well, here, they broke the deal, and they should face the reform and the remedy is what has already been agreed to in the Constitution, which is the people's representatives that they voted for in this election will pick the president by state delegation in accord with the constitutional remedy. And so that is why that case has the best case for a chance of success. And if the Supreme Court does not take that case, it means they're not going to get involved in this election. If they do take that case, it means that Trump is in the game. It is indeed a game changer. Thanks, everybody.